What's up everybody, welcome to Money Management channel. My name is Andrei and today I'm gonna be doing an update on MMTLP and FINRA saga.
I got the cash in the bag, stadium packed, born a rock star in this life, gonna live it up.
And on today's second video, I want to share with you this information. I have to say that recently Roza Tawil made some updates regarding her lawsuit, and unfortunately, as you can see on Pace Monitor, we don't have any updates right here. The latest one was made on May 24th, but thanks to due diligence, he made a very thorough update regarding this lawsuit, and he made his summary, and I will share it with you right now. And before we dive deep into all of this, please hit the like button, subscribe to my channel, share this video with your friends and family, and drop me a line in the comment section for whatever reasons you want. So, due diligence wrote, MMTLP. In other news, did you know that FINRA responded to Roza Tawil's second amended complaint all the way back in July the 6th? I have uploaded the document here, and he posted the link, and I have to say that, as you can see, it was filed on July the 6th, and unfortunately Pace Monitor doesn't reflect this update. So let me go to further. To summarize, FINRA basically has 5 points of opposition. Futility of amendment. FINRA is arguing that Roza's second amended complaint would still be subject to dismissal, even with her different approach. They are saying that it lacks valid grounds for the relief she is seeking. Regulatory immunity. FINRA has once again asserted that they are entitled to regulatory immunity, which applies to its actions and financial regulator, regardless of Roza's allegations or motives. Next one, failure to state a claim. FINRA say that Roza's second amended complaint does not establish any cause of actions or valid legal claims. It argues that the Roza requesting for an accounting of the shares lacks sufficient grounds. No private cause of action. This one is interesting to me. FINRA is making an argument that there is no private right of action against a self-regulatory organization like FINRA for its regulatory acts or omissions. So, what they are saying is that even if they didn't have immunity, the law does not provide Roza with the right to take legal action against FINRA for their regulatory acts or omissions, regardless of the specific circumstances or reasons she might have. So, quite interesting statement. Next one, lack of jurisdiction. FINRA is saying that the court lacks jurisdiction, and they are saying that Roza's claims fail to meet the requirements of what is known as diversity jurisdiction in the legal system or federal question jurisdiction. Believe it or not, they are actually saying that the federal court doesn't even have the right to hear this case, which to me is kind of nuts. Yes, it is ridiculous how it is even possible. Next one. In short, FINRA is asking the court not to grant Roza leave to amend her complaint and to dismiss her case entirely with prejudice, which would bar her from filing another lawsuit against FINRA for these causes of action. Now, did you know that Roza responded to this opposition? Stay tuned for part 2. So much for a vacation. And let me show you the second part. It is right here. On July the 20th, Roza filed a memorandum to the court in response to FINRA's opposition. You can find that here. Again, he published the link. Let's get into the summary of the points Roza is making. The halt. Roza points out to the court that it has been 7 months since FINRA halted trading, and during this time NextBridge Hydrocarbons shares have not been issued to her and other shareholders. She rightfully says that this occurrence has caused significant uncertainty, fear, and financial losses for all NBH shareholders. Short positions still exist. Roza explains to the court the basics behind shorting. That short positions involve borrowing shares from shareholders with an obligation to return them later. So then points out that private companies like NBH are not eligible for shorting as they are not tradable. She says that before issuing shares, short positions needed to be closed. She then follows up by citing that Cromwell, CEO of the OTC markets, who I still would love to have in a space call, by the way, revealed that FINRA did not enforce the obligations that shorters have, and that this favored brokers and entities with short positions, thereby causing financial injury to herself and other regular shareholders. Next one, violation of fiduciary duty. Roza states that FINRA's failure to regulate unreturned short positions after 45 days and allowing the halt to continue without doing so amounts to a breach of their fiduciary duty. She says that as a regulatory organization, FINRA is supposed to protect investors and uphold securities laws, but their actions seem to prioritize other interests, other those of shareholders. Shareholders' disenfranchisement. I love this one. Roza is asserting that due to the lack of clarity on shareholder positions, shareholders are unable to exercise their rights effectively. They cannot hold shareholder meetings, seek direction from the board of directors, or participate in company decisions, and she is right. Unreconciled shares. Roza points out that NBH has issued the shares to brokers for distribution, as they were supposed to, but brokers are unable to distribute them to shareholders due to the imbalance, which she says that conservatively is estimated to be over 100 million shares. She says that this unreconciled difference forces a dilemma on shareholders and may lead to dilution of their interests or a total loss without judicial intervention. Benefit of halt. Roza argues that the halt imposed by FINRA worked in favor of obligors, brokers with short positions, but disadvantaged regular investors and shareholders. She is suggesting that FINRA didn't do their duty and may have done so out of potential favoritism or conflicting interests. Article 3 standing. Roza is standing her ground on her right to bring the case-by-case stating that she got MMTLP shares through a merger with Torchlight Energy, which she was a shareholder of, and that she also bought more shares through purchasing MMTLP directly. Subsequently, she says she has full rights as a shareholder and should not be denied legal remedies and recourse. Absolute immunity. Roza is saying that FINRA's claim of absolute immunity needs to be questioned, stating that it should be reviewed on a case-by-case basis. Given FINRA's involvement as a regulator and also market investor with significant financial interests, the court should carefully examine whether their actions are truly immune from legal consequences. Mootness dispute. Since FINRA is arguing that the case is moot, Roza is countering with the fact that the issues remain unresolved until shareholders can exercise their rights and/or until she actually gets her shares of NBH. She says that this blatant lack of transparency in FINRA's actions demands that the court gets involved to protect shareholder interests. Next one. Roza is really highlighting that we still don't have our shares. She's also heavily emphasizing the impact of short positions and alluding to potential conflicts of interests on FINRA's part. Finally, she's saying that shareholders' rights have been denied here, and all of this raises serious concerns about FINRA's actions and their potential violations of securities laws and fiduciary duties. I commend her on the approach she has taken here. Roza, thank you. You aren't trying to use this as an advertising ploy for your legal work. You aren't criticizing people or causing division. And you are keeping to yourself during this process like a true professional should. For all of this and more, you have my gratitude. Good luck, my friend. And I have to say that this is a brilliant summary of the latest updates regarding Roza's lawsuit. And I have to say that, in my opinion, Roza still has all the chances to win her lawsuit and to help us as a community to win our battle in general. That is why I have to give a huge shout out to Due Diligence and Roza Tawil, because these people are still our headliners, and despite the conflict between due diligence and Mark Basil. I think everybody is trying to solve this problem, and everybody is trying to do their best. And I think that's all information that I want to provide you. If you like my video, please hit the like button and subscribe to my channel with notification bell. And see you guys and girls next time. Bye.
I got the cash in the bag, stadium packed. Born a rock star in this life, gonna live it up on the